Okay, I'm back. Here we are again. We are doing lesson 5, bill drafting, and this is lesson 5 part 2 video. And problem 3 in drafting is when laws are not aligned with legislative purpose and intent. Now, what is purpose? Purpose is the overall goal or objective. For instance, we want to increase affordable housing. It's a more general, global type thing. Intent or meaning of specific terms, language, or policies in a bill. So intent would be what constitutes an affordable house. So again, the purpose is the overall goal or objective to acquire affordable housing. Intent would be how do we define what an affordable house is? Now, when laws are not written clearly or their purposes are not articulated, it falls upon judges to determine how they should be interpreted. If legislators and bill drafters can't write laws unambiguously and in alignment with their intent and purpose, they should at least leave a trail of evidentiary breadcrumbs for the judges to see, to help them in their interpretation. So, when judges are confronted with a question about what actually was the legislative purpose or what was the legislative intent in interpreting a law to help them figure out how to rule, they will rely on most of them rely on one of two approaches or a blend of the two. The textualist approach looks at the law's plain language even if the result is questionable or absurd. Straight English grammatical interpretation, and a textualist judge will say if this creates an absurd outcome, then the legislature needs to come back and rewrite the law. Most judges, though, would follow a purposive approach, and this would attempt to discover the legislature's purpose by researching the circumstances that drove the law's passage, along with statements made by legislators, on the floor of the debate in committee hearings. There is a third approach that some judges use, and that third approach is the activist approach, where judges believe that they need to interpret the law to promote their concept of justice, and that this often involves them totally rewriting the whole purpose and intent of the law. These judges are not faithful to the democratic principle that legislators write the laws and judges just interpret the laws. Okay, let's look at the application of these approaches. One famous case was Riggs v. Palmer. And this involved a young man who knew he was named as a recipient in his grandfather's will, but he feared that his grandfather might change the will before the grandfather died to disinherit him. So the young man preemptively killed the grandfather. The court decided that the young man should not receive the inheritance because giving it would fly in the face of legislative purpose. The court believed that the legislature would never have intended that the young man receive the inheritance. A strict reading of the law would have allowed the young man to get the inheritance because it only mentioned fraud or senility when the will was signed as reasons to throw a will out. But the court followed an interpretive rule that states that just because an action is within the letter of a law doesn't mean that it is written with the spirit of the law, especially when the outcome appears contrary to the legislature's intent, which would create an absurd result. Clearly, the legislature didn't intend for people who killed their grandfathers to collect an inheritance from them. Okay. Another was Church of the Holy Trinity versus the United States. The U.S. Supreme Court in 1892 interpreted a federal law that restricted hiring foreign laborers to perform labor or services to not apply to a minister from England that the church had contracted with to be its pastor. The question here was, is a pastor, right, a laborer or service provider within the context of the federal law that was being applied to the pastor to try to deport him? The court conceded that the church's actions violated the letter of the law because he was providing a service, but in considering the title of the law, which had to do with foreign laborers, circumstances of its enactment, the definition of labor at the time, statements made during the passage of the law, and the absurd result applying it in this case would create, the court ruled that it was not intended, it was not the intention of the legislature to ban ministers. The title and the wording all made it clear that this law was meant to keep out cheap manual labor and cheap servants who would compete with Americans and not pastors. So again, you see all the different things that a judge can look for when they're trying to discern, a purposive judge would look for in trying to discern what was the purpose and the intent of the legislature. All right, now, those are the grammar canons. Let's move on to the substantive canons. The substantive canons are interpretive rules based upon foundational principles of law in our system of law, and they promote justice, individual rights, consistency, and fairness. So they're principles that promote these good things. The first is the rule of lenity. And it says, when there are ambiguities in criminal law, they should be resolved in favor of the defendant. This is in criminal law now, not civil law. This is based on the fact that a defendant in a criminal case often faces harsh punishments, and consequently, you would want to give that person the benefit of the doubt when the law is ambiguous. It also does not allow unelected judges to expand the scope of criminal law, which would be undemocratic, for them to make things illegal that weren't intended to be illegal or to increase penalties. The rule of lenity. There's also a principle called expressio unius est exclusio alterius. Translated into the English, to express one is to exclude others. So judges use this principle, again, in interpreting laws. If a list of specific words is not followed by a general word or words, then the law only applies to the specific words listed. So, in the case of R.V. Harris, which was back in Old England, a statute said it was illegal to stab, cut, or wound another person. The court therefore applied the canon of expressio unius and refused to find the person guilty of the crime of biting a police officer's finger. Had the law said it was illegal to stab, cut, wound, or otherwise injure, then the biting of the finger would have been covered, because otherwise injure is a general term. But in this case, there was no general term, so we only go with the expressed ones under this principle. Other substantive canons only create the right to sue when clearly stated in the statute under scrutiny. There is a disdain for civil litigation and the expense and the court time that it takes up. So you don't let somebody sue unless they have a clear right to do so in statute. Another substantive canon is to interpret laws whenever possible in ways to avoid constitutional problems. This is kind of a concession to legislators. So if you can interpret it in a way that is not constitutional, when challenged, let the law stand. So the judicial branch is a little reluctant to overturn the behaviors of a legislative branch. Again, the separation of powers. Another canon, only change the common law when the statute is meant to do so. Now, the common law is judge-made law. It is law that came about from the interpretation of statutes over the years, many, many years back. And for a long time, common law was the law of the land everywhere. But in the 60s and 70s, we began to switch from common law, which you can only find by reading judicial decisions, to statutory law, law passed by legislators. So we only change the common law, though, when the statute means to do so. So we keep it until the legislature changes it and overrides it. Another one is avoid interpreting laws that give them ex post facto which means retroactive application. It is unfair to hold somebody to a penalty for doing an illegal act, or for an increased penalty when they committed the act before the actual act was made a crime, or before the penalty was increased. To go back retroactively and make somebody guilty for something which was legal when they did it, or to go back retroactively and increase the sentence for an illegal act they committed then but had a lesser sentence, is just not fair. So we don't allow ex post facto laws. Common law. I spoke a little bit about the common law and ex post facto. Let me go into a little more depth. So common law, again, is called judge-made law. It derives from judicial decisions contained in judges' past written opinions. When these opinions come down from higher courts, they are called precedents, and the lower courts are bound to follow them to provide consistency in the law. The common law does not trump statutory law, which is superior, but again, statutory law can't undo common law unless specifically intended to do so. So statutory law trumps common law. Ex post facto, Latin for after the fact, applies to the retroactive application of laws and penalties, which is illegal because it violates the due process and the principles of fairness. Another basic principle is the avoidance of absurd outcomes. Judges assume that no legislator would write a law and no legislature would pass a law that creates absurd outcomes. And that's like almost always true. I've known some weird legislators. So the rule against absurdity allows judges to reject interpretations resulting in absurd results. However, who decides what's absurd? A textualist judge might let the absurd outcome stand, warning the legislature to correct the error in the future. But what happens if the legislature doesn't do so? And this kind of happens. Legislatures are sometimes reluctant to change laws that they disagree with, even when they've been overturned by the courts, and even when they've been overturned by the voters. I'll give you an example. Consensual sodomy is deviant sexual intercourse between persons not married to each other, so like single people. Right? For all my years as a police officer in New York, the consensual sodomy law had been ruled unconstitutional by the highest court in New York State, their court of appeals. And however, no legislature wanted to write and sponsor a law, and many didn't want to vote for a law that removed the ban against consensual sodomy, even though it was unconstitutional and couldn't be enforced, because it could be used against them in an election, saying that they favored sodomites. We have the same dynamic happening in Arizona right now, where the voters greatly expanded when abortions can be performed at the polls, which overrode the state law, which was not as permissive. But Republican legislatures do not want to repeal the existing state law, even though it's void and can't be enforced, because of the flack that they would get from their pro-life constituents and voters. So that's a little politics into the law. Let's talk about how you inoculate bills against judicial misinterpretation. You know, a legislator doesn't want his laws to be misinterpreted. You want your purpose and your intent to be the law of the land, not what some judge, what some lawyer asserts and which some judge confirms in court if it's challenged. Complicated bills that contain subjective elements, poor grammar, and controversial bills that are destined for court challenges, they're at a high risk of misinterpretation. And they should be inoculated by the bill drafter, the legislator, against misinterpretation by including sections on intent, findings, and purpose within their text. So in the law itself, you would have written a section on this is the intent of this law. Then you would have a section on findings, and that's the factual basis for the law, maybe research that was conducted. And finally, you would put the purpose. A purpose statement saying what the desired outcomes are in a broad and somewhat abstract manner. And these sections would go in the front at the top of the law, although they would not be published in the law books that the people see. These would simply be in other volumes that lawyers and judges have access to if they need this information. Other drafting issues. Let's talk about severability clauses. These are also called savings clauses. And they state that if any part of a bill or law is ruled unconstitutional or otherwise invalid, other sections of the bill or law that do not rely on the invalidated section are still valid. So if a law has 3 or 4 different moving parts, and one of those parts is ruled unconstitutional, the other ones would still be in law. But before you put a severability clause into a bill, bill sponsors need to decide whether they would want the bill or law to live on if it was altered that way. If some important part were removed, do they still want the other parts to be there? So that's the decision you make on whether or not to put a severability clause into a bill. There's also the single subject rule. We have something called log rolling, which involves legislators putting different disparate subject matter provisions into a single bill. So putting a highway appropriation into an education bill. The education and highways are 2 different things. Sometimes legislators will put like a highway bill to repair a highway in their district in an education bill, knowing the education bill is popular and will be passed, and they get their highway bill along with it, as opposed to running the highway bill separately, and maybe it gets voted down because not that many people want it. Combining unrelated subjects into a single bill increases the chances of legislators favoring one provision and opposing other provisions. And that's why a lot of states have single subject rules saying you can't have more than one subject area in each bill. This log rolling, throwing disparate provisions in, can occur as part of a quid pro quo between the bill's sponsor and another legislator who needed a vehicle to introduce a failed bill. So my bill failed. It was the road bill. I make a deal with the Ed Chair Committee in the other chamber that I'll hear his bill in my committee if he lets me amend my bill onto his bill in his committee. So you wind up with two disparate provisions, transportation and ed, in one bill. And that's log rolling for a quid pro quo. Bill sponsors also engage in log rolling to win the votes of other legislators. I'll put this, if I put this in, will you vote for it? It's prohibited in many legislatures because the problem is it puts legislators in a bad situation, not to mention voters if it's a ballot measure. Because if you like one measure and hate the other, you're either going to have to not vote for the good one because the bad one's very bad, or you have to accept the bad one to get the good one. So it puts the person in a bad dilemma. So they all have to be the same subject matter. You can have multiple road bills in one transportation bill. You can have different education policy in one education bill, but you can't mix those subject areas. Let's talk about standalone versus integrated laws. A standalone law is one that can function independently of other laws because critical features, its definitions and processes for enforcement, are self-contained in its little section. A standalone law would contain sections on its purpose, scope, applicability, definitions used in its interpretation, penalties, defenses, and necessary administrative processes, all in the one bill, which creates one section of law. But if all laws were standalone, the law books would be unnecessarily voluminous due to them being overpacked with duplicated sections. A lot of the sections, especially sentencing sections, definition sections, apply to all the law. So to have to repeat them in each individual law in the law book makes the law book too big. So that's why you will often see integrated laws. And that's one embedded into the existing law, which shares common components with other laws, including sentencing provisions and administrative directions. The key to success in this drafting dilemma between standalone versus integrated is the sweet spot between the two, between total independence of the rest of the law or over-reliance on other laws. A littering law is an example of a very standalone law. If you look at littering statutes, they're like 20 lines long. They define littering, they define the penalty. It's real simple. One or two definitions. Racketeering laws, on the other hand, are, if they were standalone, they would be like 100 pages in themselves. Because racketeering laws usually make it illegal to engage in behaviors that promote other illegal activities like human trafficking, drug dealing, entering into conspiracies to do this. So they are usually integrated, and all the different things that comprise racketeering, which is belonging to an association. Racketeering is belonging to an association that engages in ongoing criminal enterprises. And the ongoing criminal enterprises are the drug dealing, the burglaries, the human trafficking, and all the other stuff that they do, extortion. So those are integrated, so you don't have to repeat all those legal sections in the one law of racketeering. Drafters also need to check for proper internal references, cross-references, and conformity to existing law when they draft these integrated and standalone laws. You want to make sure in an integrated law that you're referencing the right sections, like in the racketeering, the correct burglary and drug sale and what have you. And you want to make sure that the standalone law conforms and doesn't contradict with other sections, especially like with the penalties and processes for enforcement. All right. Special legislation. Special legislation is legislation that applies only to specific groups, persons, entities, regions, or situations. It either grants its targets benefits, privileges, or exemptions from onerous laws, taxes that are not available to others, or it imposes burdens, regulations, or duties on them. Special legislation often involves giving tax breaks, relief from regulation, exemptions from laws, bailouts of failed businesses or ventures, or the granting of monopolies to like utilities or something. It is sometimes illegal and controversial to do special legislation because it often involves favoritism, cronyism, discrimination, quid pro quos, corruption, payoffs, unconstitutional deprivations of due process, and a lack of equal protection under the law for the people who don't get the benefits or the bailouts, or even the appearance of such things. Arizona has a constitutional ban on many forms of special legislation. Other states only ban special legislation in certain situations. Still, others allow it if there's a rational basis for it. And California allows it, but only when it is passed by a supermajority vote. So different states deal with it in different ways. Bills, resolutions, and memorials. Bills are the proposed laws introduced into the legislature. That's what we've been talking about in this class. Resolutions are formal legislative statements that offer opinions, express intentions, or make similar statements. They don't have the force of law. They often just commemorate people or events, declaring legislative positions on current issues, or create internal legislative rules. So resolutions might, honor some group that did something nice. Memorials are formal requests by or statements from a legislature to outside bodies, often the Congress of the United States. Memorials either make requests, voice support for or opposition against something, usually a bill, or urge action on some big issue before the country. In Arizona, memorials are jokingly called postcards to Congress. I don't think anybody in Congress even reads them. They're more for us and our constituents. And resolutions and memorials usually pass by a voice vote without controversy or even some people looking up from doing their emails on the floor. Drafting as an ongoing process. The process of bill drafting does not end when the bill is dropped in the hopper. Many bills require multiple amendments at different stages of the process, and crafting these amendments can be just as tricky as drafting the initial bill, because the amendments are often made on the fly, had to be done real quickly. Last week of committee, we have to have this on, and these on the fly amendments are usually based more on the need to compromise than on a desire to create a good bill. All right, so that's it for Lesson 5, Part 2. I hope you enjoyed it. Bye-bye.